Good day, everyone. We are the Family Court Group, and we will be presenting the procedures on how to file a case violating the provisions under Republic Act number 9262, otherwise known as the Anti-Violence Against Women and Their Children Act of 2004 or the Anti-VAWC Act of 2004. Under the provisions of the Anti-VAWC Act of 2004, the victim, parents or guardian of the victim, relative of the victim, the social worker, police officer, barangay captain or punong barangay or barangay kagawad or concerned citizens may file in writing for a barangay protection order or BPO in any barangay where the victim, survivor, or the petitioner is located or where she resides. So in cases where the parties resides in different municipalities or cities, the barangay captain or punong barangay or any kagawad of the barangay where the victim survivor resides shall assist the victim survivor or the applicant in filing an application for a protection order from the court within 2 hours from the request. So the place of residence or location of the victim survivor or the petitioner may include a place where the victim survivor temporarily resides or where she sought refuge or sanctuary to escape from and avoid the continuing violence from the respondent. This is pursuant to Section 409 of the Local Government Code of 1991 and its implementing rules and regulations. It is to be noted that violence against women and their children is a public offense, which may be prosecuted upon the filing of a complaint by any citizen having personal knowledge of the circumstances involving the commission of the crime.
The victim, parent or guardian of the victim, relative of the victim, social worker, police officer, punong barangay or barangay kagawad, or concerned citizens may also directly file a verified petition for a temporary protection order or TPO or a permanent protection order or PPO in the family court with territorial jurisdiction where the offense was committed. If no family court exists, the application may be filed in the Regional Trial Court or RTC where the crime or any of its elements was committed at the option of the complainant. A temporary protection order refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some, or all of the reliefs mentioned in the Act and shall be effective for 30 days. The court shall schedule a hearing on the issuance of a permanent protection order prior to or on the date of the expiration of the temporary protection order. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff, who may obtain the assistance of law enforcement agents for the service of notice. The TPO shall include notice of the date of the hearing on the merits of the issuance of a PPO. A permanent protection order refers to a protection order issued by the court after notice and hearing, respondent's non-appearance despite proper notice, or his or her lack of a lawyer, or the non-availability of his or her lawyer shall not be a ground for rescheduling or postponing the hearing on the merits of the issuance of a PPO.
The court shall, to the extent possible, conduct the hearing on the merits of the issuance of a PPO in 1 day. Where the court is unable to conduct the hearing within 1 day and the TPO issued is due to expire, the court shall continuously extend or renew the PPO for a period of 30 days at each particular time until final judgment is issued. The court shall not deny the issuance of protection order on the basis of the lapse of time between the act of violence and the filing of the application. A standard protection order application form, written in English with translation to the major local languages, shall be made available to facilitate application for protection orders, and shall contain among others the following information. A. Names and addresses of petitioner and respondent. B. Description of relationship between petitioner and respondent. C. A statement of the circumstances of the abuse. D. Description of the reliefs requested by the petitioner. E. Request for counsel and reasons for such. F. Request for waiver of application fees until hearing. And G. An attestation that there is no pending application for a protection order in another court. If the applicant is not the victim survivor, the application must be accompanied by an affidavit of the applicant attesting to A. The circumstances of the abuse suffered by the victim survivor, and B. The circumstances of consent given by the victim survivor for the filing of the application.
When disclosure of the address of the victim survivor or petitioner will pose danger to her life, it shall be so stated in the application. In such a case, the applicant shall attest that the victim, survivor, or petitioner is residing in the municipality or city over which court has territorial jurisdiction, and shall provide a mailing address for purposes of service processing. An application for protection order filed with a court shall be considered an application for both a TPO and a PPO. Barangay officials and court personnel shall assist applicants in the preparations of the application. Law enforcement agents shall also extend assistance in the application for protection orders in cases brought to their attention. If the woman or her child requests in the application for a protection order for the appointment of counsel because of lack of economic means to hire a counsel de parte, the court shall immediately direct the Public Attorney's Office or PAO to represent the petitioner in the hearing on the application. The lack of access to family or conjugal resources by the applicant, such as when the same are controlled by the perpetrator, shall qualify the petitioner to legal representation by the PAO. However, a private counsel offering free legal service is not barred from representing the petitioner. The court may order any person against whom a protection order is issued to give a bond to keep the peace, to present two sufficient sureties who shall undertake that such person will not commit the violence sought to be prevented.
Should the respondent fail to give the bond as required, he or she shall be detained for a period which shall in no case exceed 6 months. If he or she shall have been prosecuted for acts punishable under Section 5A to 5F and not exceeding 30 days, if for acts punishable under Section 5G to 5I of the Act, a punong barangay, barangay kagawad, or the court hearing an application for a protection order shall not order, direct, force, or in any way unduly influence the applicant to compromise or abandon any of the reliefs sought in the application for protection order under this Act. Section 7 of the Family Courts Act of 1997 and Sections 410, 411, 412, and 413 of the Local Government Code of 1991 shall not apply in proceedings where relief is sought under the Act. Failure to comply with this section shall render the official or judge administratively liable. Law enforcers and other government personnel shall not mediate or conciliate or influence the victim, survivor, or applicant for a protection order to compromise or abandon the relief sought. The statement, "Violation of this order is punishable by law," must be printed in bold-faced type or in capital letters on the protection order issued by the punong barangay or court.
Barangay officials in the courts shall schedule and conduct hearings for a protection order under the Act above all other business, and if necessary, suspend other proceedings in order to hear applications for protection order. Failure to act on an application for a protection order within the reglementary period specified in the previous sections without justifiable cause shall render the official or judge administratively liable. The court shall expedite the process of issuance of a whole departure order in cases prosecuted under this Act. A complaint for a violation of a BPO issued under this Act must be filed directly with any municipal trial court, metropolitan trial court, or municipal circuit trial court that has territorial jurisdiction over the barangay that issued the BPO. Violation of a BPO shall be punishable by imprisonment of 30 days without prejudice to any other criminal or civil action that the offended party may file for any of the acts committed. A judgment of a violation of a BPO may be appealed according to the rules of court. During trial and upon judgment, the trial court may motu proprio issue a protection order as it deems necessary without need of an application.
Violations of any provision of a TPO or PPO issued under this Act shall constitute contempt of court, punishable under Rule 71 of the Rules of Court, without prejudice to any other criminal or civil actions that the offender may file for any of the acts committed. The provisions on protection orders shall be applicable in criminal cases and or shall be included in civil actions deemed impliedly instituted with the criminal actions involving violence against women and their children. If the victim is an indigent or there is an immediate necessity due to imminent danger or threat of danger to act on application for a protection order, the court shall accept the application without any payment of the filing fees and other fees and transcript or stenographic notes. All records pertaining to cases of violence against women and their children, including those in the barangay, shall be confidential, and all public officers and employees and public or private clinics or hospitals shall respect the privacy rights of the victim. Whoever publishes or causes to be published in any format the names, addresses, telephone number, school or business addresses, employer, or other identifying information of the victim or an immediate family member without the latter's consent shall be liable to the contempt power of the court.